It is a great honor to welcome Professor Hadley Arkes on this program. He is the Professor of Jurisprudence Emeritus at Amherst College. He is currently the founder and director of the James Wilson Institute and the author of a wonderful new book, Mere Natural Law, Originalism, and the Anchoring Truths of the Constitution. Hadley, welcome to the show. Thank you for joining us.
Thanks very much for inviting me in, Sean.
Okay, so let's begin with the James Wilson Institute. What is its founding mission?
Well, the James Wilson Institute was named after one of the premier minds of the American founding, James Wilson, a Scot immigrant, and who followed closely the work of the great Scot philosopher Thomas Reid. Wilson was one of the signers of the Declaration of Independence and the Constitution. He was on the first Supreme Court, and he delivered a remarkable series of lectures at the university, what became the University of Pennsylvania Law School. The purpose of this James Wilson Institute was to try to restore to a new generation of Americans, lawyers, judges, and citizens, the furnishings of mind of those remarkable men who created the American regime and the Constitution, because they began with principles that were there before the Constitution, anchoring truths that were there before the Constitution. They drew upon them in framing the Constitution, and they recognized it would be necessary to keep appealing back to those first principles in explaining the judgments they're reaching in cases. And we find ourselves in a situation now where we have so many conservative lawyers who think that if they have to leave the text of the Constitution, there are no moral truths outside the text of the Constitution. Whereas the founders who were relying on those truths would often appeal to them. And of course, as Jonathan Ginup, the historian, said, the founders never think they were putting in the Constitution everything they knew. And so suddenly we're discovering implications of our own principles that, for example, anyone accused of a crime should have access to the witnesses and evidence against him so that he has a chance to rebut them, and rebutting them, producing a verdict that is substantially accurate, distinguishing the innocent's guilt. Well, the founders, they didn't put that in the original text of the Constitution. They didn't think it was necessary to put it there. It was added in the Sixth Amendment. But it's an example of many other things that would have been articulated by judges along the way, even if they haven't been in the text. So it's a task of recovery. But with the natural law, I was appealing to the notion of C.S. Lewis, maybe mere natural law seems to draw on
mere Christianity,
an allusion to mere Christianity, where in a very accessible book, where C.S. Lewis would point out that in the conversation among children, one could find serious arguments. They're appealing to not simply expressions of likes and dislikes, but arguments over matters of right and wrong. And they were trying to appeal to rules and give alternate arguments. And of course, the whole conversation made no sense unless the kids already presupposed that they're assumed that there were standards of judgment at work. They could tell the difference between plausible and implausible answers, right and wrong answers. And so I was going to go back to that and the way James Wilson would go back to Thomas Reid he invoked Thomas Reid in the very first opening lines of the very first case that is set down in the U.S. reports, Chisholm versus Georgia, in 1793, where Wilson said, we're at the very beginning of the American law. We have no distinct precedents to draw upon under this Constitution. So we must go back to the general principles of jurisprudence. But even before that, we have to step back and go back to the principles of mind on how we know anything. And he appealed then to the writings of Thomas Reid in that common sense philosophy, set against those doctrines of moral relativism, skepticism, that under bold but false pretensions to liberality, prevailed in Europe at the time that he was writing. In other words, for Wilson, before we can ascend to the task of judging, we had to recognize that there were indeed principles of judgment there, principles making practical judgments, and things were good or bad, better or worse. And the move to the American law meant that a detachment from the doctrines of moral relativism in all of their forms. Now, Wilson, to just add one more point to Chung, that Wilson and drawing on the great Thomas Reed, would draw upon those precepts of common sense that the ordinary man just has to know and take for granted in getting on with the business of life. So before the ordinary man would start trafficking in theories or bantering with David Hume about the meaning of causation, he knew his own active powers to cause his own acts to happen. And that became the lead, that we're dealing with those things so anchored in common sense that the ordinary person has no trouble grasping them. He asked the ordinary person, give the ordinary person this problem. Jones, accused of a serious crime, was undergoing surgery at the time the crime was committed. I think the ordinary man would say, why are you punishing him? Why are you prosecuting him? That is to say, the ordinary person will recognize what Thomas Reed and Kant and even Aquinas recognized as the first rule of all moral and legal judgment, that we can't hold people responsible for acts they were powerless to effect. We cannot cast moral judgments of praise or blame on people for things they were powerless to do. And for that simple proposition, which is true of necessity, it has to be grasped, as Alexander Hamilton would say, per se note. We grasp the truth of it in the way that we grasp the truth of the law of contradiction, the two contradictory propositions both cannot be true. We grasp it as evident, it's evident on its face, the notion that we can't hold people blameworthy for things they're powerless to effect. That the crime was committed before Smith was born, we take it as powerful evidence of his innocence. Well, that proposition is true of necessity, which means there's no place in the world it would not be true. There's no time in which it would not be true. And you're getting back now to what Lincoln said in regard to Jefferson and the Declaration of Independence, that he took this moment, a revolutionary moment, to articulate an abstract truth about the right of human beings to be governed with their own consent. We don't govern human beings the way human beings are compelled to govern horses and cows. That Jefferson took that moment to articulate a truth, as Lincoln said, applicable to all men and all times. And so my pitch here has been that if we take the ground of the natural law, the moral ground of the Constitution, then, as the founders understood it, they would be anchored in those anchoring truths, which, like, we don't hold people blameworthy for acts they're powerless to effect. Anchoring truths, which are indeed timeless, will be true in all cultures and all times, applicable to all men and all times, as Lincoln said. There's certain things that are so fundamental that people can talk themselves out of it only if they've been instructed in theories. So that's what we're running up against, that people who can't seem to acknowledge in the law that the child in the womb is indeed has the standing of a human being, even though the findings of embryology have been utterly clear on this for 70, 90 years. So, some kind of theory, jurisprudential theory, is getting in the way. You saw me cite in the book that line of Jefferson's in a letter to he said, you could give the same problem to a professor and a plowman, and the plowman is as apt to get it right because he will not be distracted by artificial rules, called them theories. For we've seen now lawyers in this country masking to themselves the most objective truth, the difference between males and females, erecting some kind of theory of the Constitution that somehow bars the judges from recognizing those necessary truths. And that's a good measure of the situation we're finding ourselves in now, what brings forth this book.
Mhm. Well, Jefferson was famous to have said, the tree of liberty must be refreshed from time to time with the blood of patriots and tyrants. And
Yeah,
from
yes.
a non-American perspective, I think the difference between conservative jurisprudence, broadly speaking, and liberal jurisprudence is that for conservatives, the tree of liberty is there, it has already been there, and it's our job to protect it, safeguard it. And for liberals, the tree of liberty is still like in its infancy, and we can grow it according to new findings.
Oh, it's raging. It must be a liberty that detaches itself from any kind of natural restraint. Right? This is the doctrine of sexual liberation must detach itself from anything in nature that would separate men from women and remove any moral inhibitions about sex between consenting adults or man-boy relations, or perhaps even the zoophiles, human-animal relations. It's as the doctrine of liberating us. Talk about liberty, liberating ourselves, the fullest liberation from all restraints. You produce something that will finally devour itself. I think we're beginning to see that in this country.
Mm-hmm. So the title of your book, yeah,
that sounds grim. That's true. Okay.
The title of your book has originalism in it, which is a judicial philosophy that is, for the most part, embraced by conservatives. There are a good majority of them in the current U.S. Supreme Court, but nevertheless, you've had a good amount of criticism towards it. So, well, first, we have to define what originalism is, and two, what are some of your disagreements towards it?
Well, we're all originalists. I mean, I've spent many years teaching the American founding. Of course, we have to admire the American Constitution, one of the most remarkable documents produced in the mind of man, and recognize the remarkable character of those people like James Wilson, Alexander Hamilton, James Madison, who Gouverneur Morris, who had a hand in shaping everything. Okay, so some of the passion for originalism came at a time when people thought that judges were simply inventing new rights, not in the text of the Constitution. So the clamor came up for no, respecting the Constitution as it was written. Of course, if we understand the Constitution and we understand what was important about getting and what was valuable about this Constitution, then of course we want to apply it as fundamental law, taking it seriously, applying it as it was meant, as it was understood. And some of us, of course, would teach the American founding by going back to the writings of people like John Marshall, Alexander Hamilton, James Wilson, who could give us the most luminous account of how they understood this Constitution they had shaped. Right? But the problem came as conservative lawyers began to talk themselves out of a concern to cabin the judges. They talked themselves into the notion that any time a judge left the text of the Constitution, he was engaged in something illicit and wrongful. He was inventing new rights. And so the argument about abortion was not as much the killing of the unborn child as much as the abortion was not in the text of the Constitution. Therefore, federal judges had no grounds for proclaiming new rights arising out of the Constitution. Of course, the federal government had ample reason to be dealing with the matter of abortion in the United States, dealing with abortion in military hospitals, diplomatic installations, military installations abroad, abortion in the territories of the United States, Rico, Guam, or in the District of Columbia. So and of course, there's nothing in the text of the Constitution about marriage before the court struck down the laws in Virginia that barred marriage across interracial lines. But the conservatives, in their desire, in their passion they wanted to deal with judicial activism by trying to rein in the judge's cabinet as closely as possible, by teaching that it was wrongful to go beyond the strict text of the Constitution. So they talked themselves into a kind of terminal positivism where they barred themselves from doing the kinds of things that the founders are moving outside the text of the Constitution to explain the very grounds of their judgment. And so right now, with the Dobbs case overturning Roe versus Wade, the conservatives have done all they think they could by saying abortion is not contained in the text of the Constitution. But they would not announce anything about the rightness or wrongness of abortion, or even recognize the human standing of the child in the womb. That goes beyond that very limited scope that they've taken for themselves as the rightful province of judges. And the results, I think, have been catastrophic because for 50 years, after Roe versus Wade, sustaining these laws, beating back challenges over 50 years, the court was persistent, reaffirming what is considered to be the deep rightness and goodness of abortion, its importance to women. The current court, in overturning that, did nothing to offset it. The court had changed the culture. It converted abortion from something being abhorred, discouraged, forbidden, into something approved, encouraged, promoted. And now we would return the issue of abortion into a culture that's been formed in that way. And the lawyers are just astonished that this pro-life movement has suffered so many reverses of people, that the opposition scares people about some critical rights that are going to be taken away from them, which is just implausible. But it's a mark of the fact that the culture had changed. The conservative jurisprudence did not think it had any obligation to engage, as John Marshall said, Republican schoolmasters that the court teaches. I mean, we wouldn't have had the movements that led to the Civil Rights Act of 1964 were not for Brown versus Board of Education and the court taking the lead on racial segregation to teach new moral lessons in the country. That's what was needed as part of the movement to overturn Roe versus Wade, but the court has not engaged in that. And that's left us in what this perilous situation we're in right now.
So going back to James Wilson, you've outlined in the book Mere Natural Law that he has a quarrel with that great jurist William Blackstone about English common law. And so while Blackstone would say that the law applied to the land of England, or the rights applied to the citizens of England, is a privilege upon the people being born in the British Isles, Wilson would say that Wilson would disagree. So how did Wilson disagree with Blackstone?
Well, take the most fundamental level. Blackstone said that when we leave the state of nature and enter civil society, we give up those unrestricted rights we have in the state, the right to do anything in the state of nature, including the liberty to do mischief. To which Wilson said, when did you ever have the liberty to do mischief? Or as Lincoln would later say, when did you ever have the right to do wrong? We understand a wrong is something that no one should be doing. No one should be doing. When did you have a right to do something that we regard as wrongful? And so the critical difference was that Wilson and Hamilton assumed that the human beings, even in the state of nature, were human beings with moral competence who can reason about right and wrong. And so the argument was that when we restrain people from, when you enter civil society, and we have laws that restrain people from murdering and raping, we're not depriving them of anything they ever had a rightful liberty to do. And so when the question was raised in America, what rights are we giving up in entering under this Constitution? The answer tendered by the Federalists was none. Alexander Hamilton said, here the people surrendered nothing. It was not the object of this project to surrender our natural rights, which gave rise to the further question of, if that's the case, why are we attaching something called codicil, called a Bill of Rights, listing those rights we had not given up to the government, unless you now were implied that indeed we had given up the bulk of our natural rights to the government in exchange for a few rights under civil society for the sake of having this government. That's created a serious confusion over the years. You know, people say, I invoke those rights I have under the First Amendment, right to speak and to associate, as though in the absence of that amendment, you would not have those rights. In other words, the concern among some of the Federalists was that you were misinstructing the American people about the ground of their rights. These are rights that flow to people by, to take a line of James Wilson, it was not our purpose to invent new rights under this Constitution, but to secure and enlarge those rights human beings had by nature. So if we say that no man has by, it's wrong to rule human beings in the way that human beings are compelled to rule horses and dogs. That human beings are moral agents, they should be governed with the rendering of reasons in a regime that elicits their consent. If we raise the question, where in the world will it be wrong to rule human beings the way human beings are compelled to rule horses and dogs? The answer would be, well, everywhere, anywhere in the world, that their difference in nature between men and animals remains the same. Hence the notion of natural rights, rights grounded in an enduring nature that separates human beings from the things that are subhuman on the one hand and superhuman on the other, from animals and from God. Remember, the other argument was no man was by nature the rule of other men, in the way that God was by nature the rule of men, and men were by nature the ruler of horses and dogs. And Jefferson, in the famous line, said, anyone who denies that has to assume that the mass of mankind were born with saddles on their backs and a privileged few born with spurs on, ready to ride. And so there's nothing entirely abstract about this notion. Ordinary people readily understood it. It's curious that some of the commentators, well, there's something abstract about this doctrine. No, we have this remarkable document, I say it in the book, from the end of the 18th century, of some slaves in Massachusetts petitioning the government institutions for their natural rights to be respected as free men and to be removed from slavery after slavery removed from them or for their children, gradual admission. There was nothing abstract or inscrutable about this, the understanding of these deep natural rights.
Mm-hmm. Well, I think
no, that's a critical mark. You know, it was it's a famous line of Hobbes where he said, "The passions of men are no sin. No more are the actions that proceed from those passions, till they know a law which forbids them, which till laws be made, they cannot know." In other words, we have no moral reasoning before the law. Nobody can afford to assume that anyone around him is going to be putting himself under moral restraints, that we have no capacity for moral reasoning until we have the laws. And that's the critical divide. Hamilton said of Hobbes that he rejects the existence of that superintendent principle, that is God, who is the source of a moral law that will be there even when civil institutions decay or are destroyed before they come down. That's a critical difference here, separating Wilson and Hamilton from people like Blackstone and Hobbes, and even Rousseau would hold that no, we cannot afford moral reasoning until we are all under the restraints of the law and it's under the government.
I believe it was Jeremy Bentham who did the utmost to, advance legal or judicial positivism set of natural rights as nonsense on stilts.
That's right. So nonsense on stilts, right, right.
So, I think for Bentham, human beings are behavioral animals rather than rational or even moral animals. We are guided by our desire to pursue pleasure and avoid pain, hence his utilitarian philosophy. But
Right.
Wilson and the long line of great natural law thinkers that went before him, Thomas Aquinas, Cicero, amongst other, believe that humans are moral animals. We have a desire to think morally, and we know that if a certain behavior that gives us pleasure, but we find to be immoral, that is not to be, also vice versa. Um, so
Right. With Aristotle, that people may find their pleasures in doing some deep. They might find their pleasures engaging in lynching. May find their pleasures in doing all kinds of wrongful things. So the question is where do grown-ups, mature people, find their rightful pleasures, not simply pleasure alone. And of course, that was. I'm sorry, I don't want to break your movement here, John. Just to point out that it was for Bentham a moral theory. It's just that he reduced morality to matters of pleasure and pain. Yeah, I'm sorry. Go on, please go on.
okay. So what I was getting at is that we are living in an age of rapidly advanced science where we have certain machines that can predict our neurological patterns when we do certain things, and
Uh-huh.
and of course that's where I think positivism has its roots, right? It is this idea that science can predict human behavior in ways that other, I guess, systems of thought cannot. So uh, how would you make the case that humans are moral beings, uh, in opposition to this Benthamite case that, well, humans are just pleasure seekers, so to speak?
Well, there's only one kind of creature who understands what it means, who can make a promise, can make a commitment, and honor that commitment, even when it's counter to his own inclinations or appetite. Lincoln had marvelous line in his Cooper, I think it was the Cooper Union speech. He referred to those black slaves who didn't throw in with John Brown, late insurrectionists. And he said, as illiterate as they were, as uneducated as they were, these slaves, they had this good sense to see that the schemes of this crazy white man were not going to conduce to their well-being. In other words, they may be illiterate. They're not book learned, but they are moral agents. They are beings who can reckon their own interests, who can also then have a sense of their attachment to other people, to people they love, to children, parents. They're aware of interests of others they would take seriously. They can reckon their own interests, their own well-being. They have an understanding of the well-being of others, comes along with the whole their natural endowments. And it would be wrong simply to annex these people, however uneducated they were, annex them to the purposes of other men without their consent. Lincoln would say the one reason that these slave uprisings don't work is that the slaves will have an affection for people in the household, for the children they've helped to raise, for the mistresses that they've come to like, and they will warn them. In other words, they will have what comes along in the nature of a moral agent is that he can not only reason about his own well-being, but he has his sentiments will reach out to be too concerned for the well-being of others, especially those he loves. Not everyone will do that. Some people will be entirely absorbed in themselves. We know that. But we know it is part of the capacity of human beings to respect a law outside themselves. And it was Plato would have it, that we understand the difference between a man who can respect the law outside himself, under self-control, and the man who knows no law beyond his own appetites. Well, only human beings have that capacity. Only remember Chesterton remarking that animals have no religious sense, and he asked, when was the last time you heard of cows giving up grass on Fridays? Well, you might as well have, they have no moral sense either. They cannot lie. They cannot make a commitment, give a promise. Leo the 13th, in that marvelous encyclical of his on liberty, I think it was 1888, said the difference between men and animals is humans are the only ones who can judge whether they are directing their liberty to ends that are rightful and lawful. Animals cannot impart any moral purpose to property, to inanimate matter. Only human beings can impart that moral purpose. So when we're talking about rights, we're usually talking about the rights that are accessible to rational creatures, creatures who can reason about their rights. And if they make their way also to the recognition that I don't have a right to do wrong, these are beings who may really, without that much instruction, really come to understand those things they have no right to claim, even in their standing as moral agents, as free men. Not to make slaves of other men, not to abuse their children, and so on.
So one thing I tremendously respect about the natural rights doctrine is that it's universal. But of course, unfortunately, this is a concern that both you and I share. The idea of rights, at least in the US, have taken a very particularist strain. I think it was after the Civil Rights Acts, the conception of rights has been more group-based, right? You have gay rights, women's rights, trans rights, animal rights, if you so choose. So this form of thinking about rights, so to speak, while if you're a liberal, you can make it that, well, you're enlarging the circle of liberty to include all manners of being. We conservatives would think that it is inherently divisive and strays away from the universal moral message of natural rights. I'd like to hear your thoughts on that.
Well, the decisive difference and mistake was detaching claims from rights from their moral ground, from the explanation of what made them rightful. I mean, Jews and blacks could have, a right not to have racial hostility inflamed against them because they happen to be Jewish or black. It's the point is, as simply articulating rights. I may be able to strike the person next to me. It doesn't mean I have the right to do it. I may be able to take my own life. It doesn't mean I have the right to do it. I may want to take my life because I think I'm guilty of the war, I'm guilty for losing the war in Vietnam. Just wrongful. I may take my life because I think I have a grandparent of the wrong color. I may take my life because I think I'm guilty of some other crime I didn't do. It would not be a justified ground for taking my own life. It could be, when we do that, we say it's self-murder. So the problem of all these things is simply proclaiming rights as though they're there. The matter of gay rights, of a sexual life. It used to be, well, it's a matter of taste. It's your taste, but not my taste. And if he says, I said, yeah, that's what you do. It's not my taste. Then the argument is, well, no, it's wrong for you to form an adverse judgment. Why is it wrong to form an adverse judgment? If I object to some parts of the homosexual life and the as wildly practiced with multiple partners and so on, why would it be wrong for me to object to that? if it's a matter of it's what is the ground for what the bars me from objecting to it? Uh, if this is simply a matter of taste that simply respond to it, it's not mine. And the critical move now was to say, it is you're you're wrong to cast judgments on the gay life, and you may not cast. It is wrong to cast judgments, right? And it's wrong for you to cast judgments. The only thing people who are doing anything wrong are the people who are casting judgments. But with what is left unexplained is just why it is. What is there about this that bars people from having an aversion to it? They just have an aversion to two men marrying. They have aversion. What is wrong with that? Why is some problem with it? What makes it absolutely wrong for me to hold to that? That hold to the notion that marriage is understood rightly as a marriage between a male and female under a legal commitment to frame a relation involving the begetting and nurturing of children, with a legal commitment marking the fact that the partners have foregone the freedom to quit this relation as it suits their convenience. It makes a natural fit. I mean, you don't always need that kind of framework for friendship. I have a deep friendship with Fred. Tennis is never the same without Fred. So a legal commitment that I make, that Fred is compelled to play tennis with me every Thursday. We don't think we need do that for the case in case of friendship. We thought it was quite necessary in a matter of to frame that relation, bringing forth children for the begetting and nurturing of children, and even in those cases when the marital relation breaks down, that framework, that legal commitment, gives us the ground for making judgments about who bears custody for those children where a marriage breaks down. It was as a framework filled with not rights, but with obligations and duties. And we just didn't see. Now, let's say I just don't see why. I don't see why that should be applied to males, to two males or two women. And as Justice Alito said, what you've created in the decision in Obergefell in installing same-sex marriage is you're installing an argument that will cast other people as bigots if they simply have a different view of the matter, an objection to it. And that's what we're seeing. For example, with the matter of the masterpiece baker of Jack Phillips, who was reluctant to make a cake for a same-sex marriage, two men. He's willing to treat customers who happen to be gay or lesbian, there's no problem there. But he was not willing to become complicit in this by endorsing this marriage. Well, our libertarian friends say, oh, just don't pick on him because there are many other people who make cakes. And what they don't understand about the people on the other side is that they fiercely believe that it is morally wrong to reject same-sex marriage. And those who reject it, it's not a matter of whether I can get cakes anywhere else. It's a matter of putting in place emphatically the moral judgment, this is rightful, anyone who opposes it is wrong. Lincoln, in that critical passage, said, if I conceded that slavery was right, yes, it's true, all the words and constitutions against it would be wrong and could be swept away. And I guess I could concede to you, you're right to censor the abolitionist literature to keep it out of the federal. If slavery was right, all words against it would be wrong. And that's what's engaged here. You see, the people, you see, for the partisans of slavery, it's not enough that we're silent. We must be avowedly with them. We must affirm the rightness of slavery. And with the matter of same-sex, it's not enough that people get get cakes or other services by other people who don't have the same moral reservations about same-sex marriage. It's that the people who do have those reservations must be stamped as wrongdoers, and as wrongdoers punished in some way. Mm-hmm. So where does that leave us? We've covered quite a bit of the ground here. Good questions, John. It's your show. Where do you want to lead on from here? I mean, you've covered,
right.
you've been put in place many quite important things. Okay.
Okay, and I intend to continue on my train and
Don't let me distract you. Okay, don't let me tear you off your path. Okay.
Yeah, I was just it's the show is intended for the guest to take up as much time as he or she likes. So I'm mindful of that particular space. But nevertheless, as you were forming your answer, I was thinking about your neighbor up north, which is Canada, where they instituted this program called medical assistance in dying, which it's a euphemism. It's euphemism for people who seek to end their life voluntarily. Even people who are perfectly healthy who just have like a few too many bad days or something like that. So perhaps it may not be the creation of new rights as you may have put forward, but the interpretation of existing rights with such broad scope and scale that the rights themselves sort of lose their meaning and significance. I'm also thinking about how the right to free speech, the First Amendment in the US, have been used to justify the creation of distribution of, say, pornographic material, such as Deep Throat and Hustlers magazine. And
yeah, I know. That's another thing that separates me from some of my friends on the conservative side, that the conservatives have been slipping to doctrine of relativism. But okay, now I don't want to take you away from your main point. You're talking about the right to die.
yes.
And I think the problem there is that it's nothing novel. They take a novel turn in making those kinds of arguments. The argument's been with us for many years, but there's nothing novel about the framework. I mean, we talk about self-murder, but the wrong of suicide. That if you killing yourself for no serious reason, because you hold yourself responsible for some wrong that someone else did, or you think that no one with my disability anyone with my disability, if I Down syndrome, deserves to die. Well, you're saying that anyone with Down syndromes could be rightly killed. We used to have a term for this. Talk about unalienable rights. Rights so deep whose wrongness does not depend on your consent. You're right. You don't have a right to contract yourself into slavery. And no, you don't have a right to kill yourself because you're a member of the wrong race. The question is, what are the grounds on which you're claiming that this is rightful for you to do? Nothing has changed in all of that. And when people are claiming the right to die, what they're usually doing is wanting to compel doctors and nurses to act as agents in a killing that may not be justified, to make them takers of life. There was this famous case many years ago of Elizabeth Bovia, a quadriplegic in California, who thought her life was worthless, and she's in her 20s. She wanted to die. She could have died at home, but instead she had her father deliver her to a hospital. And in the hospital, she tried to make the case of her right to die and compel doctors and nurses to become agents in her purpose. And in making that argument, she argued to the court that she had a perfect right to kill herself because she had a life utterly devoid of moral purpose. The judge agreed with her, and at the same time gave her lawyer's fees. Why? Because she just pushed through the court a case, an outcome with high public interest and importance. And so taken was she, though she had professed to have lost her taste for food. Her taste for litigation was unappeasable. How she won? She wanted to stay around and argue more, which is say, even in her diminished state, she so showed that she's capable of living a life of moral purpose. So that is so much engaged here. And once again, it's this matter of just taking rights outside of the framework in which you have to explain, well, what is rightful about them? Rightful about them. But you're moving off to a later point. I don't want to.
Yes. Right.
Let's go back to the other point you're raising.
Okay. Yeah, what I was getting at is, I think coincidentally, what you were getting at too is that this
Speech.
broad interpretation of existing rights, not only does it have the effect of diminishing the significance and the moral basis for why we have rights to begin with, it creates a situation where rights are no longer like positive sum. For example, my right to free speech does not diminish your right to free speech in any way. But if you brought up the baker and the gay wedding couple, another example would be if a given young person decides that he or she is trans and goes to a doctor, so he or she has the right to do so, but the doctor in question does not have the right to refuse anything beyond, I guess, gender affirming treatment, so to speak. And that this whole broadening of rights and freedoms may have the inverse effect of reducing rights and freedoms, at least for individuals. Yeah.
Of course, it just happens. We look on both sides. If you bar discrimination on the basis of race in private businesses open to transactions with the public, you're diminishing the freedom of those owners to conduct their business the way they wish. But you're telling parents. I never thought I'd live. You're. I don't know what it is now in Austria. Maybe getting close to us, but I never thought I'd live in a regime in which parents could be threatened with punishment if they were seeking counsel for a child who was confused about his or her sexuality, and could be charged with so detaching themselves from gender affirming care that they could plausibly lose custody of their own children. It's the whole scheme works by utterly detaching the whole question from whether it is indeed true that people can be in the wrong body. Well, no, you're not in the wrong body. You were born, it's the body you were born into. It has a very definite sexual character by your organs. That no, we cannot cosmetically, we cannot surgically change a man into a woman, or a woman into a man. It's cosmetic surgery, and it's disfiguring surgery, and it's scarring surgery. It'll produce many harms along the way, and it is already begetting suicides. And the curious thing is how this kind of thing can be pushed. Well, what's at work here now, Charles? Something that's so scary in our national life. It's detaching these arguments from any test of reality. That unborn child in the womb has never been anything other than human from its first moments. The ground on which we take that human life must be the same plane as the kind of arguments we demand for the taking of any other human life. The difference between males and females is just confirmed in nature. There's no way to unsay that. There's no justification for creating a situation which Anthony Stevens thinks he's a woman, and the rest of us are obliged to respect that judgment as though we're true. Or climate change. I mean, people are now, climate quite detached from any serious reckoning of the evidence on the threats of climate change or the damage of climate change and how much human beings contribute to it. And yet our lives are being altered here with just the distortions of public monies put into green projects and electric vehicles and so on. Because people curious how people want the passion for these ends and these rights proceed by utterly detaching themselves from any claims, testing of objective truths. And that's how we preserve, I suppose, the passion that won't be stilled as we pursue these things. The right to speak. I mean, this is The court recognized, the founders recognized that speech could be a source of injury. You could be rousing hostility to a racial minority. You could be sending threatening letters to people, making threatening phone calls. Speech can be a vehicle for injuries as well as anything else. And the founders understood this. Our classic case of Chaplinsky versus New Hampshire in 1942, they recognized that we don't need physical touching to have an assault. You can assault, you can hold an unloaded gun, as somebody said. You can shoot and deliberately miss. You can make dismissive gestures. But there's a recognition here that speech can become the vehicle of harms. And it's quite legitimate to ask people in this arena as anywhere else, what is the justification for the harm you're inflicting? What is the justification for burning a cross outside the home of a Black family and trying to generate terror in their hearts? I'm afraid that the conservative judges are apparently worried about conservatives being set upon not having the proper freedom in the academy, think they can solve the problem by trading to a doctrine of relativism. There is nothing so offensive that it cannot be illegitimate. I mean, this is remarkable. We have Nazis parading in Skokie, Illinois, in a community containing Jews who survived the Holocaust. You're telling us just because, is it wrong only because it offends them, or something wrong in principle about scaring people by bringing back all the signs of swastikas and armbands and brown shirts of these thugs in the streets? In the realm of speech also, we've detached ourselves from the recognition that comes with ordinary language. There's certain terms in the language that are simply understood as terms of defamation or insult or crude. The F word, the N word. At any given moment, people must know what they are because they're used for the sake of mocking or actually wrecking a conversation instead of responding to the argument. I say, F you. And everyone recognized it is a mockery and an attempt to break off any kind of civil conversation. And the judges have put themselves in a position where they can't seem to recognize those elementary points that came along with those classic cases. And so the problem here is, if it's moral relativism, if there is nothing so offensive it cannot be legitimate, then there's no moral ground for defending the rightness of free speech. It's like Mussolini, an old line of Mussolini's from the early 20s saying the great thing about the doctrine of cultural relativism, it shows that we cannot be wrong in pursuing the policies of our party, of the fascist party. No, it's an illusion, and it's in a self-defeating illusion for conservatives to think that they're going to do something to protect conservatives by backing into a position of moral relativism on speech. Mm-hmm. There's an old line, I think, that came from Lincoln, that people have an obligation in the first instance to respect the very premises on which their own freedom rests. And those premises involve our capacity to make judgments about rights and wrongs, things that are right or wrong, and knowing that it's not really our subjective feelings or tastes, but there are actual grounds for making those judgments. Mm-hmm. Well, you've covered a lot, John, in this period. Mm-hmm. Is there anything we've left out?
I think it'll be a good time to conclude, but I would like to follow up with the free speech example first. Well, sure, I think people who call themselves a free speech absolutists, I guess the ACLU of old would borrow that line from H.L. Mencken, right? The problem with securing rights is that you have to be on the same side of SOBs and scoundrels and scumbags and etc. because that's the state often comes for them first. So yeah. How'd you raise an objection to that?
This came out. This came out so precisely in the argument 40 years ago over self-styled Nazis parading through the streets of a Jewish neighborhood containing survivors of the Holocaust in Skokie, Illinois. And Dave Hamlin of the American Civil Liberties Union said, we must be free to hear the Nazis because we must be free to choose the Nazis.
Mhm.
Think of it. Choose it. The Nazis would sweep away all of the rights that the ACLU is seeking. It would sweep away the Constitution that defends this. Now, if you take a look at this, from what does that freedom to choose arise? From that underlying principle that no man is by nature rule of others. The only rightful government over human beings depends on the consent of the governed, manifested through free elections. If we're saying that a party that would do away with free elections altogether is as legitimate as any other party, what are we saying? We're saying that the regime itself, the commitment to a regime of elections, to government by consent, is not true. It's no more or less true than anything else on offer in our politics, which is to say that truth of the Declaration of Independence, all men are created equal, the only rightful government over human beings, is not what the founders and Lincoln and Madison thought it to be, an absolute truth that would apply in all places in the world where we could separate human beings from animals by nature. What you're saying is, no, we don't regard that as a truth. It's simply one opinion, no more or less valid than any other opinions on the street, including the opinions that would remove the protections of law and strip whole population, Jews say, of their civil and political rights. I mean, that kind of relativism brings itself to, as just say, that it cannot defend any longer the moral ground of a regime of free speech. This is how people talk themselves into devour themselves, seek a liberation so complete that it destroys itself. That there's another line I have. The problem, as I said years ago, the problem of the case in Skokie and the Nazis in Skokie was not a matter. The problem is not that ragtag bunch of characters who style themselves Nazis. The real problem with it was a bunch of lawyers from the best law school who talk themselves out of the moral premises of the freedom of speech and the moral premises of their own constitutional order. That was the deepest problem.
Well, to conclude, so how would you and also James Wilson answer this question? What are rights for?
What are rights for? Well, the whole purpose of life is to lead an upright and good and rightful life. If you ask, it's like an old friend of mine, Dorothy Dubin, said in New York, what is good as happiness? Can it get you money? It's say, what is the value of doing unto others as you do unto yourself? What is the value of not holding people responsible for acts they were powerless to effect? Does it raise our income? Or is it simply right in itself? Are we arranging our lives, our own lives, in terms of principles that are rightful? There was a marvelous passage in Aristotle in the Ethics where he says, the study of politics and talking about the principles on which we're arranging our life, living our lives. This may not be of much interest to people who are very young and whose life consists of a series of random episodes. But if you really have in mind to live in a different way, where the things you're doing next week are connected to what you did this week and next year, that you think there's some kind of a set of principles that describes your life, that accounts for the life you're living, well, there's something about that is good in itself, regardless of whether it will get us tickets to the best shows or raise our incomes. So if you say, what is the good of morality? It's, well, the good of a moral life is that it's something intrinsically good. And it'll be good for us even if it doesn't lead us to the best marriage or the best job or the best income.
On that wonderful, wonderful note, thank you very much, Professor Hadley Arkes, for joining this show.
Thanks so much for inviting me, John. Very, very dear of you to invite me.